there's my number, there's our website. Please don't hesitate to try to contact me with any questions you have. So let's just sort of dive right in. I'm assuming that everyone on this call has some level to greater or lesser extent of what we mean by IP. I don't want to insult anybody, but let's just sort of march through these because the topics today are going to focus on the patent side of things. So you have patents that protect inventions, you have trade secrets that protect confidential information. Trademarks protect the goodwill of businesses, typically represented by a word or a logo, think Nike and the swoosh. And then copyrights sort of are the other basket that protect original works of authorship. Again, we're going to focus on the patent side of things for this presentation. So let's just keep rolling here. Okay. So again, what this seminar is all about is how to help your company avoid IP issues. And we'll cover sort of three main aspects, and that's avoiding loss of patent rights, right? How to help you avoid things that can trigger loss of rights. We're also going to discuss avoiding third-party liability, and that is kind of a misnomer. Sometimes you cannot avoid third-party liability, but there are things you can do to mitigate liability. And then something you should also be aware of is avoiding potentially damaging communications, for example, in emails, social media, things like that. All of these can have an impact on, or it could create IP issues that you may or may not be aware of. So let's sort of go through this. So, why is all of this important? Again, most of you, if not all of you, are at some stage of startup to a little further down that road. But, I'm sure most of you, if not all of you, are starting to think about how do I start to attract investment dollars? And that is, in my experience, one of the very first questions that investors will ask. They will ask about the strength of your IP. And what they mean by that is, have you done all of the things necessary to protect your IP? Have you done things that are necessary to ensure that you're not infringing somebody else's IP? And do you have the proper mechanisms in place as a company policy to avoid any, accidental disclosures or spurious things said in social media or by email? These are things that you really need to pay attention to and be aware of, because again, this will be among the first questions that are asked by anybody looking to give you money to help fund your company. And the reason why is investors want they want to invest in exclusivity, right? They want to know that what they're investing is wrapped up as tight as can be. And they will do due diligence on their end. They'll hire people like me. I've represented investors for years to go into a company and do a deep dive into their entire IP portfolio and figure out what strengths and weaknesses and what things need to be done better and all that kind of stuff. And also, it's going to come down to they're asking my opinion about the valuation of their IP. So paying attention to these things may not necessarily increase the valuation, but if you don't pay attention to these things that we're about to talk about, they will definitely decrease the valuation of your IP and ultimately your company. This also holds true for, if you are further down the road in your patent portfolio and you're thinking about licensing your inventions, or you're even further down the road in your company and you're starting to consider maybe a buyout or some sort of purchase or acquisition of your company. All of these things will come to a head in the IP realm, because again, this is directly tied to the valuation of your company. So that's sort of why this is of critical importance, that you pay attention to these things and start to implement best practices in your company to do this. So if I get a little long-winded here, Anita or Amanda, please just ping me and say, move along.
You're doing great.
Okay.
Oh, good. Perfect.
Yeah, again, sort of looking at our roadmap here, we the first thing that we can talk about is how do we avoid loss of IP rights in the first place, right? So you have inventive activity at your company. You want to make sure that you're not doing things that you could lose IP rights and you may or may not even know it. So let's sort of take a couple of things. Let's talk about statutory bar and absolute novelty. And this comes into play when you've invented something and you want to disclose it. You want to publicly disclose it. You want to show it at a sales meeting. You want to publish a white paper on it. You want to talk to potential investors about it. You want to show them how great your invention is. Well, activities like that could and often do start triggers that are working against you. And so you need to be aware of any type of public disclosure activities. In the United States, if you publicly disclose something, and we can get down in the weeds on what a public disclosure is, but it's probably pretty close to whatever everyone is thinking about what a public disclosure is, that's probably right. If you publicly disclose something, then that's probably a public disclosure according to the law. So anyway, in the US, you have a year after 1 year exactly after any public disclosure to make sure that you get a patent application on file. Otherwise, you will be forever barred from pursuing that as a patent. In virtually every other foreign jurisdiction, they have something called absolute novelty, meaning if you publicly disclose something, you are barred from a patent in that jurisdiction. So the takeaway here is if you have interest in foreign filing your patent rights, and we can have that discussion in another, or you can ask me questions about why or why not you would do that. But if you have interest in foreign filing, you want to make sure that you file a patent application here in the United States before any public disclosure. Otherwise, you will be barred in those other jurisdictions. And then you're going to start a clock against you in the US. This slide is a little bit, we don't need to do a deep dive on this slide, but you can just sort of absorb some information here. And it's basically saying, in the US, we have a first inventor to file scenario, right? So if I invent something and somebody else independently invents it, but I invented it first, but they filed for the patent application first, they win, I lose, right? So it behooves you to make sure that you're protecting certainly the core concepts of your technology early and often. Filing patent applications on those things as they come up. Otherwise, you may wind up in a scenario where someone else, unbeknownst to you, files before you. Okay, this is another thing that, again, this is something investors will certainly take a look at. They're going to take a hard look at what your best practices are in your company for how are you managing inventors? How are you managing who's doing the inventing? And when I say managing, what I mean by that is how are you ensuring that these inventions are wrapped up in the company? And the obvious answer is you do it by way of assignment, right? But even before assignments are executed by inventors, there are steps you can take in your company. For example, employee agreements, where you have automatic assignment clauses in employee agreements, such that the second they invent something, it has already been assigned to the company. And this becomes important because if you have inventors that haven't assigned, or if the assignment is somehow defective, they are free to exploit that patented technology without even accounting to you. So they can leave your company, go off and exploit that technology, and now you've got a competitor that using your patent. because they are a co-inventor and they are allowed to do that under the law. So the only way to wrap them up is to make sure that all employee inventions are handled with assignments, and of course, employee agreements that trigger assignments, right? This is a checklist that I sort of quickly put together last night, and we don't need to do a deep dive on any of this really, but these are things that I'm sure you've heard before, but, you know, again, reiterating the point on inventorship and make sure you secure assignments. You want to make sure you monitor any disclosure and sales activity. You want to pursue prompt drafting and filing of patent applications to make sure that you're protecting your foreign rights as well as protecting your US rights. And certainly any disclosure outside of your company should be under the guise of an NDA or some mechanism to ensure confidentiality. This is sort of a continuation of that checklist. There's a lot of information here, but the basic takeaways here are, you want to make sure that you're carrying on the practice of your business with an IP focus in mind, so that somebody critically looking at it later on is saying to themselves, wow, these guys really, they have their ducks in a row. They know what they're doing with their disclosures. They know what they're doing with their assignments. They know how to make sure that things are tied up in an NDA. They know how to protect confidential information. These are things that, again, a third party is going to look at and be critical of. So make sure that you're doing it correctly. The last bullet point is something that, I'm sure you're aware of at some level, but it's always good to highlight it because this happens more frequently than I would have believed even 5 years ago. But inadvertent disclosures, particularly on social media. We have had clients that their sales force or their sales engineers are out at meetings and they send a tweet to somebody or a Facebook page to somebody describing the next prototype of an invention in detail. That just triggered a public disclosure, right? And they didn't mean it. They were trying to get sales going, but these are the types of things that your employees need to be aware of. You really cannot discuss anything about your inventions. It's certainly not willy-nilly. You need to be targeted about how you do that, right? And then, we're in a pretty much a mostly work from home scenario now. And so you may have employees that are prototype testing at home or writing code at home or whatever. You need to be aware of that, and you need to take steps to ensure that that information remains confidential within the company, right? You don't know who's coming into the room. You don't know how it's being secured, all those types of things. Okay, so going back to our roadmap here, looking at the concept of avoiding or mitigating third-party liability, right? How can we mitigate or avoid getting entangled with somebody else's IP rights? Sorry for the scrolling. And just by way of backdrop, I'm sure you guys are all aware of this, but a patent is a negative right? It's the right to exclude others from making, using, selling what is covered by the patent, right? It's not the right. Getting a patent does not give you the right to do anything, right? It just prevents you from, it gives you the right to exclude others from doing that. Also, getting a patent does not necessarily mean that you don't infringe somebody else's patent. Somebody else could have obtained a patent before you that has broader claims than you ultimately got allowed, right? So, doing your own IP does not necessarily help you avoid entangling with third parties. And a patent lasts for 20 years from filing here in the United States and in foreign jurisdictions. The reasons why you want to avoid getting into patent contests with third parties, if you can, or at least work to mitigate it. Here's a couple of things that can happen as a result of patent infringement, right? You could get an injunction. The court could order you to say, stop making or selling this product. That happens frequently. When I litigate a case, if I'm plaintiff, I'm going to be looking to shut the other company down. And this is the nature of the exclusive right, right? The company that is alleging infringement will certainly seek damages. And those can be in the form of compensatory damages, which is at least a minimum of a reasonable royalty, or enhanced damages, which could be triple that, right? So there's significant dollars at stake when you get into the issues of patent infringement. And that's just the cost of infringing somebody else's patent. Here's the cost on this slide of what you're going to pay patent attorneys like me to defend a patent infringement suit, right? It's going to be at least $3 million through an appeal, and you have to assume going into it, most patent cases do get appealed, and that's for a modest $10 to $25 million at risk, right? So this is a modest sized patent infringement suit. There are patent infringement suits that are in the billions, right? And the potential damages are in the billions. So you can imagine how this goes up, right? So what you want to start thinking about is, how can I mitigate or hopefully altogether avoid any issues like this, right? And again, it's not always possible, but you want to assess and minimize your risks. So one of the ways that you can start thinking about doing that is patent clearances. This is otherwise known as a freedom to operate or freedom to move in the space. And what that involves is you perform a search of in a particular art unit, and you look for potentially relevant patents. Then you start to whittle it down, and you work with a patent attorney like myself, and we figure out what are the most potentially problematic, and then we do a deep dive on those potentially problematic ones and see if there's ways we can avoid infringement, right? And what happens if we find something that presents a risk? There's a couple of options here, right? You can design around it, and there are ways to think about designing around. And again, that's a deep dive once you're in the weeds of a particular patent. How can I change my technology, hopefully slightly, to avoid infringement of this patent? You could also look to license or acquire those patents, or you could perform some sort of opinion analysis that looks at the prior art and tries to invalidate the patent that is causing concern. Or, certainly the least favorite option here is you could abandon this product line and say it's not worth the risk. And that is a business solution that may be on the table, depending on who you're up against. If you're up against a huge multinational company that likes to sue smaller companies, that now your risk assessment goes up. What can you do about this? You want to be attentive to patents on other products. So you want to look for things like patent pending or any type of patent marking on other people's products. As a startup, I'm sure each of you are intimately aware with some competitors out there in your field. So you're going to be aware to some extent or another what they are doing in their IP space. You want to make sure you are aware of that, because those are the people that you are going to bump into more likely than not. Heed warnings about potential patent rights, right? So if somebody sends you a letter that says, hey, we think you're infringing this patent, that's, that's an immediate sort of, I need to get with a patent attorney right now, because there are events that are happening that need to be dealt with sort of immediately. Watch for announcements on patent grants and suits. Often, again, this is looking at your competitors. This is often done on websites and sometimes in trade journals and things like that, that they'll announce, we have this patent. We just got patent rights on, the latest and greatest statin drug, or, whatever. You'll see that and pay attention to that. The other bullet points, I'm kind of running seriously long here, and I apologize. Anybody has questions on the rest of these bullet points, I'm happy to dive into it. There's a lot here to digest. I do get that. And then let's sort of look at the third thing that we discussed of avoiding IP issues is potentially damaging communications, right? And recognize that if in a tight competitive industry, litigation can and often does occur, even with good non-infringement and or invalidity positions. So, we talked about this before. You talk to a patent attorney, we do a deep dive on some patents, and we think we have a solid position that we don't infringe. That is not good enough to keep us out of court. That's good enough to help us avoid damages, particularly treble damages, but it's not good enough to get us out of court. So litigation, by its very nature in the US, involves discovery. And that means they will discover everything about your company. Every document, every email, you will be deposed. All of the key inventors will be deposed, right? And so you sort of have to conduct your business as if every email communication that you produce, you got to, with your eye on, this email will eventually be discovered in litigation, right? And that's sort of a good practice to operate under. If you have any questions, call an attorney. Send the email to your attorney and say, hey, let's talk. Don't put anything in the email that, about your opinion, because now you have to assume again that all of this is discoverable. So again, this is what to avoid, right? You never ever want to characterize somebody else's patent in any kind of email or written communication. Leave that to patent attorneys to sort of do a deep dive, and under the auspices of attorney-client privilege, we can keep that out of discovery, but it's got to be done in the right way. If you send an email, or if one of your sales reps sends an email, or if one of your inventors sends an email to you saying, hey, I ran across this patent and boy, look at figure 4. It's exactly what we do. And I've seen that. I've seen that quite a bit. And that, now we're all scrambling to make sure that we address that and say negative things about whatever assertion was just made to help us, hopefully later on, help a little bit. It's not always perfect, but, again, you want to avoid that if possible. And there are, some terms that you want to avoid, right? Prior art. Don't call anything prior art. Prior art is a legal term. Let your lawyers, know. You can use the word patent. Don't use the word prior art. Things like infringe or obvious, right? And again, assume everything you write in an email or any kind of communication will be discovered, and it certainly will be asked for.